Today, I'd like to talk about the administrative hearing process when an individual is arrested for suspicion of DUI. When an individual is arrested, there are two processes that occur. There's the criminal case, and there's the administrative suspension of driver's license. I've spoken about the criminal case in previous videos. Regarding the driver's license, an individual has the option of requesting a hearing for the suspension of their driver's license at the Office of Administrative Hearings. Those hearings are typically scheduled in the main OAH, Office of Administrative Hearings office in Hunt Valley. Occasionally, those cases are scheduled at local MVAs depending on the facts and circumstances of the case and where the incident occurred. At that hearing, an administrative law judge will decide whether or not the MVA has sufficient evidence to prove a suspension of the license and whether or not a modified license is allowed and appropriate. The standard of proof at the Office of Administrative Hearings is significantly lower than at court. At court, the state needs to prove guilt beyond a reasonable doubt, the highest standard that exists in law. At the Office of Administrative Hearings, the MVA needs to prove their case by a preponderance of the evidence. That's the lowest standard that exists in law. In court, the state needs to use the rules of evidence to prove their case. At the Office of Administrative Hearings, the MVA uses something called the Administrative Procedures Act, which basically says if evidence is relevant and probative, it's admitted, and then the judge decides what kind of weight to give it. What that means, practically speaking, is that hearsay is admissible at administrative hearings, documents are admissible without an officer testifying about them, and the state doesn't need to lay a foundation for any kind of evidence it intends to admit. What that means, practically speaking, is that the MVA case is much easier to prove than the criminal case. If the judge believes that the MVA has proven their case, they will decide whether an individual is eligible for a modified license. On a first offense, so long as an individual blows a 1.4 or lower, they are eligible for a restricted license. What they would need to show to get that license is two things: that they need to drive and that they're safe to drive. If an individual can make that showing, the judge will almost always issue a restricted license that will allow them to drive to and from work, on the job, for any kind of alcohol education and treatment, and for any medical appointments for themselves or their family for the period of suspension.